Good afternoon, I am Emolico Reina, together with Mr. Emmanuel Landicha, the presenter for today. Evidence in sexual abuse cases. This report will go through the various forms of evidence, including but not limited to survivor testimonies, forensic findings, and societal indicators that reflect the prevalence and impact of sexual abuse. And before we begin, let us put ourselves in presence of our God. Heavenly Father, and your beloved Son Jesus Christ, thank you for another life to enjoy, another day to learn, and a new set of things we will experience. As we go through our lessons today, may let us be instrument to do good things. Help us be obedient, honest, and kind to one another. Please bless our teachers, our schools, and the students. In Jesus' name, amen. The contents of our reports are sexual abuse and its types, role of evidence, types of evidence, consent, sexual assault kit, and example case. Sexual abuse and its types. Sexual abuse refers to any non-consensual sexual activity or coercion that causes harm, discomfort, or distress to an individual. It involves the violation of a person's autonomy and personal boundaries by engaging in sexual acts without their explicit and voluntary consent. Sexual assault. A broader term that encompasses non-consensual sexual activities which can include penetration, attempted rape, or any form of sexual contact forced upon the victim. Rape. The penetration of the victim's body, often involving intercourse without their consent. Rape is a severe form of sexual assault. Child sexual abuse involves the exploitation of a child for the sexual gratification of another person. This can include molestation, rape, or exposure to sexual activities. Sexual harassment, unwanted and inappropriate sexual advances, comments, or behavior that create a hostile or intimidating environment for the victim. Types of evidence. Physical evidence, also known as real evidence or material evidence, is a tangible object which can tie the defendant, the witness, or the victims to the crime scene. Physical evidence help the examiner or investigator to recreate the crime scene and infer the sequence of events that might have taken place. Physical evidence, being objective in nature, can be used as a solid and reliable fact to prove or disprove statements from the individuals involved. It is through the combined understanding of the physical evidence and statements from various parties involved that the judge make a decision in a case. DNA evidence. DNA evidence uses your unique genetic code to link you to a crime scene or exclude you as a suspect. DNA can be extracted from blood, hair, skin cells, and other bodily fluid left behind at a crime scene or on a victim. DNA profiling was first used to arrest a rapist in 1987 and has since become a powerful tool in forensic science. DNA evidence is not infallible and can be challenged by factors such as contamination, degradation, human error, or false matches. Autopsy. The purpose of an autopsy is to acquire information surrounding an individual's death. This information may include the dead individual's identity, the cause of death, such as cancer, multi-organ failure, severe trauma, the manner of death, such as whether it was natural, suicide, or homicide, the mechanism of death, such as whether there was a severe blood loss, poisoning, strangulation, an estimate of when the death occurred, which become less accurate as time passes. Who performs an autopsy? Autopsies require medical professionals with special training. These medical professionals are called pathologists. Part of their training covers how to examine dead people's body and their organs in order to acquire relevant information. Clothing and personal items. In criminal investigation, clothing and personal items are often considered important physical evidence. These items can provide crucial information about a crime and may be collected and analyzed to support an investigation. Testimonial evidence. Testimonial evidence can be defined as sworn statements of witnesses made in open court. In its broad sense, this type of evidence includes oral and written statements made by witnesses under oath and the statements procured by the police from witnesses, victims, or suspects during interrogation. Victim statements. A victim statement, often referred to as a victim impact statement, is a written or oral statement provided by a crime victim or someone affected by a crime to describe the impact of the crime on their life. These statements are typically presented during the sentencing phase of a criminal trial or at a parole hearings and serve to provide the court with the first-hand account of the emotional, physical, and financial consequences of the crime. Witness statements. Witness statements are accounts provided by individuals who have observed an event, incident, or crime and are willing to share their observations with law enforcement, legal authorities, or other relevant parties. These statements play a crucial role in investigation, legal proceedings, and trials, providing first-hand accounts of what individuals witness. Expert witness. An expert witness is a special type of person that is called to provide expert witness testimony. For example, a DNA expert might be called to testify about skin cells found under the victim's fingernails that link the accused to the crimes with a very high probability. Most of the time, an expert witness will be an independent professional who has no prior connection to either of the parties or the facts of the specific case. Unlike the fact witnesses, an expert witness is generally paid for his work, including for time spent at the trial to give his testimony. Psychologist as expert witness. When a psychologist is called as a witness in a case involving a child victim, their role is to provide expert testimony based on their professional knowledge and experience in the field of psychology. The psychologist's testimony can contribute valuable insights into the psychological well-being of the child, the impact of the alleged incident, and other relevant factors.
So I am Emmanuel A. Landicho, and I am going to continue the discussion about types of evidence. Next, we have electronic evidence, also known as digital evidence or e-evidence. Refers to any information or data that is stored or transmitted in electronic form and can be used as evidence in legal proceedings. This type of evidence is increasingly prevalent in the digital age and can encompass a wide range of information. This evidence plays an increasingly important role in sexual abuse cases as digital evidences, digital devices and online communications have become a central part of our modern life. This type of evidence can be critical in establishing the facts of the case, corroborating victim statements, and proving the guilt or innocence of the accused. So here are some key aspects of electronic evidence in sexual abuse cases. We have text messages, calls, and emails. Text messages, call records, and emails can provide important evidence of communication between the victim and the accused. They may contain threats, explicit contents, or admissions of guilt. The timestamps on messages can establish the timing of interaction. For example, in a harassment case, the victim's email corresponds with the alleged harasser, containing threats or inappropriate messages can be introduced as electronic evidence. Next, we have social media. The public or private social media posts and messages can offer insights into the relationship between the victim and the accused. Posts or messages may contain evidence of harassment, grooming, or prior interactions that are relevant to the case. We have cyberbullying or online harassment. So the evidence of cyberbullying, online harassment, or threats made by the accused on various digital platforms can be critical in establishing a pattern of abusive behavior. Example, derogatory posts made by the accused on victim's social media page can be presented as electronic evidence. Next, we have the surveillance footage. The surveillance cameras in and around the crime scene can capture visual evidence of the incident or the movement of the victim and the accused. This evidence can establish or can help establish the presence of individuals at a particular location and time. Example, in a criminal case, the surveillance footage from a store may be used as electronic evidence to show a suspect's presence at the scene of the robbery. Next, we have the computer or phone records. The records of online activity, including browsing history and searches, may provide context and corroborate the victim's account. GPS data from mobile devices can help establish the location of the victim and the accused at specific times. Example, in a missing person case, the GPS data from the person's smartphone may be considered electronic evidence to trace their last known location. And lastly, we have the digital images and the videos. So if they are relevant, it can serve as visual evidence. This may include explicit content, photos, or videos related to the case. Example, in a vandalism case, security camera footage showing the accused damaging property can use as a electronic evidence. So it is important to note that the collection and preservation of electronic evidence must follow strict legal and forensic procedures to ensure its admissibility in court. This evidence should be collected, stored, and presented in a way that maintains its integrity and authenticity. Additionally, it's crucial to be aware of the legal requirements with obtaining and using such evidence in the case. Next, we have the character evidence. In sexual abuse cases, it can pertain to the character and reputation of both the victim and the accused. This type of evidence can be introduced to establish a person's general character traits, or to impeach their credibility. So here are some examples of character evidence in sexual abuse. We have evidence of accused good character. Example, the defense may present character witnesses who can testify to the accused good character, demonstrating that the accused is generally known as an honest, law-abiding, and moral individual. These witnesses might be friends, family members, co-workers, or community members who have observed the accused behavior over time. We also have evidence of accused reputation in the community. Example, testimony from people in the community who can attest to the accused reputation for integrity and trustworthiness. This can be used to show that the accused is not the type of person who can commit the alleged sexual abuse. We also have evidence of victim's character. Example, in some cases, the defense may attempt to introduce evidence related to the victim's character, particularly if they believe it's relevant to the case. For instance, they might present evidence of the victim's history of making false accusation or engaging in dishonest behavior. Next, we have evidence of victim's reputation. Example, the defense might seek to establish that the victim has a poor reputation in the community or among acquaintances for trustfulness and credibility. So this may involve presenting testimony from individuals who can speak to the victim's reputation for honesty or dishonesty. So it is essential to note that this evidence is subject to specific legal rules and restrictions. So the admissibility of this evidence can vary by jurisdiction. So it must meet certain criteria to be allowed in court. Next, we have the consent. So consent is a fundamental concept in sexual abuse cases as it pertains to the willingness or agreement of one party to engage in sexual activity with another. Understanding and proving consent or the lack thereof plays a crucial role in these cases. So what are the role of the consent? We have legal requirement. In many jurisdictions, sexual activity without consent is a criminal offense, constituting sexual assault or rape. Consent, therefore, serves as a legal and ethical boundary that distinguishes consensual sexual activity from sexual abuse. It is also moral and ethical consideration. Consent is not merely a legal requirement, but also an ethical and moral one. It reflects the principle of bodily autonomy and respect for an individual's right and choices. Next, we have power dynamics. The concept of consent acknowledges the importance of power dynamics in sexual interactions. So it recognizes that coercion, manipulation, or force can negate an individual's ability to freely give or withhold consent. And lastly, we have communication and boundaries. So the consent underscores the importance of communication and respect for personal boundaries and sexual encounters. It emphasizes the need for clear and voluntary agreement between all parties involved. We also have the challenges of determining the consent. First, ambiguity. The consent can be complex and multifaceted issue as it is not always explicit. Communication about boundaries and desires may be vague or nonverbal, making it challenging to determine the presence or absence of consent. We have intoxication. Cases involving alcohol or drugs can complicate the issue of consent. Intoxicated individuals may be unable to provide informed and voluntary consent, leading to disputes over whether consent was given. Next, we have the capacity to consent. So it may be impaired in certain situations, such as when an individual is underage or mentally incapacitated. Determining an individual's capacity to consent can be a complex legal and a factual matter. The changing or withdrawing consent. Consent may be withdrawn at any point during a sexual encounter. Determining when consent was given and whether it was revoked during the act can be a contentious issue. We also have perceived coercion or pressure, even when individuals do not explicitly say no. They may feel coerced or pressured into sexual activity due to fear, intimidation, or manipulation. Recognizing and proving these nuances in court can be challenging. The consent in long-term relationships. In cases involving individuals in long-term relationships, the question of whether prior consent implies ongoing consent can be complex. So the court may need to assess the dynamics and communication within the relationship. And lastly, we have misunderstandings or misinterpretations of consent can occur. So particularly when nonverbal cues or signals are involved, such misunderstanding can complicate the legal assessment of consent. Next, we have the relevance of consent in court. So it is a burden of proof. So in sexual abuse cases, the prosecution typically has the burden of proving that the sexual activity occurred without the victim's consent. So the accused may raise defenses that suggest consent was present, shifting the burden back to the prosecution to disprove consent. Jury's role. So the determination of consent often relies on the jury's interpretation of the evidence presented. The jurors must assess the credibility of witnesses and the circumstances surrounding the alleged abuse. And lastly, we have expert witnesses. In some cases, expert witnesses such as forensic psychologists may be called upon to provide insights into the behavior and decision making of the parties involved, helping the court to understand the nuances of consent. Next, we have the Sexual Assault Investigation Kit or SAIC. It is often referred to as a rape kit or forensic kit, is a standardized collection of evidence and materials used to gather physical and biological evidence from a victim of a sexual assault. The purpose of this kit is to preserve and document evidence that may be critical in the investigation and prosecution of a sexual assault case. These kits are typically used by medical professions or specially trained forensic nurses and are an essential tool in the response to sexual assault. So a typical sexual assault case kit may include the following components: the swabs, the blood collection tubes, containers, documentation forms, seals and labels, comb and brush, photographic supplies, clothing bags, and packaging and envelopes. So yung comb and brush, it's used to collect the hair samples that might contain foreign DNA or other trace evidence. And lastly, we have this example case. So, the case of Nobel Brian Salvador E. De Leon, the petitioner, versus people of the Philippine respondent. So, this case shows the importance of the evidence. So, yung nangyari dito, di si Mr. Ernesto and Margarita Zuniga, meron silang tatlong anak, sina Marian, Mary Ann, and Arlene Zuniga. Tapos, itong si Mary Ann, may asawa, si Nover Bryan. Lahat sila, magkakasama sila sa isang bahay and may tatlong kwarto. Yung isa din kina Mr. and Mrs. Zuniga, yung isa naman ay kina Marian and Arlene, and yung isa naman is para doon sa mag-asawa kay Mary Ann and kay Nover Bryan. On September 20, 1997, the Zuniga spouses, together with Marian, pumunta sila sa Bulacan to attend the wake of Ernesto's mother. While naiwan sa Valenzuela si Arlene and si Mary Ann at saka si yung asawa, si Nover Bryan, which is kapapanganak pa lamang ni Mary Ann, kaya hindi din sila nakasama. Tapos, at that time, the petitioner asked permission to attend a birthday party. At about 9 in the evening, si Nover Bryan kasama yung kanyang kaibigan na si Eduardo Palomares, pumunta sila sa bahay para kumuha ng mga karaoke tapes. And bumalik na rin naman agad sila sa birthday party. And nagstay sila doon hanggang 12 midnight. And 4:30 in the morning, umuwi na ay bumalik na galing Bulacan yung Zuniga spouses and si Marian. And nang papunta na si Marian dun sa kanilang kwarto kasi kasama niya dun si Arlene, pagbukas niya, nakita niya doon si Arlene na duguan. She suffered stab wounds and patay na. Tapos, nung pagpunta niya, pinuntahan nila sina Mary Ann dun sa kwarto nila. And then, itong si Mary Ann pumunta agad dun sa kwarto ni Arlene. Tapos, ito yung asawa niya, si Nover Bryan. Pumunta siya sa sala at nagiiyak. Tapos bigla niyang niyapos yung kanyang asawa at sinabi niya na innocent na siya. And at 5 in the morning, dumating ang police. And then nakita nila na no forcible entry. Wala ding nawawalang gamit. And sa buong bahay, walang kahit anong bloodstains, kundi dun lang sa room ni Arlene. Tapos meron silang discover na evidence or pieces of evidence on top of kitchen table. Yung petition kay Nover Bryan na underwear, gray t-shirt and short pants. Tapos may nakita din silang hair strands on Arlene's bed and dinala na nga to sa laboratory for examination. So here are the pieces of evidence na ginamit nila and pinresent sa court. The specimens for DNA analysis. Ito nga yung mga nakita ng police investigators. One dirty white Hanford brief, one light gray t-shirt with DKNY print in front, several strands of hair allegedly recovered in the bedroom of the victim, and buccal swabs taken from the following: Ernesto Zuniga, the victim's father; Margarita Zuniga, the victim's mother; and Nover Bryan Salvador, the suspect. And the autopsy result, which is conducted by Dr. Noel Minay, who was the medical legal of NBI on that time. According to his report, Arlene suffered 21 stab wounds produced by a pointed instrument, one side of which was sharp, like a balisong or a kitchen knife. And a serology examination result found that the briefs and the shirt were positive of type O human blood, which is similar to the victim's blood type. However, according to Supreme Court, they declared that the individual pieces of evidence may not be sufficient to point to the accused as the author of the crime. However, when taken together, they are more than enough to establish beyond reasonable doubt that the accused has committed the crime of homicide. And ito nga yung different circumstantial evidence. According to Supreme Court, prior to the fateful night when Arlene's lifeless body was discovered, several witnesses saw petitioner in possession of a balisong. The NBI autopsy result, sabi nga doon, yung sustained na wounds ni Arlene were inflicted with the use of weapon, only one side of which was sharp, which is katulad siya nung balisong or kitchen knife. And after the discovery of the crime, the balisong was nowhere to be found. Tapos, ito namang si Nover Bryan, sinabi niya na ibang balisong yung meron siya. However, hindi niya naipakita. He failed to show kung nasaan yung or failed to produce kung nasaan yung weapon na sinasabi niyang iba dun sa balisong. Next is petitioner's shirt and brief. As to this evidence, as correctly correctly held by the trial court, they were found to be sustained or stained with type O blood, which is similar to the victim's blood type. And also, yung absence of scratches and bruises on the petitioner's body part. Siyempre, wala siya, kasi gabi yun nangyari. Pwedeng inatake ni petitioner yung victim between 1 to 4, 1 p.m., 1 a.m. to 4 a.m. Which is, siyempre, tulog na tulog doon. Tulog pa nun si Arlene, yung victim. So, nagising lang siya nung pinuntahan siya ni petitioner. So, parang, according to sa Supreme Court, hindi gaanong kalakasan ng time na yon si Arlene kasi nga, syempre, parang galing siya sa tulog. So, she was not in a position to offer strong resistance. That's why walang mga scratches or bruises na stained ang petitioner. Also, dun sa petitioner search and brief, diga may mga dugo. So, yung mga dugong yon, as it is stained with type O blood, kahit siyempre sasabihin naman natin na hindi lang naman si Arlene ang may type O blood. Pero nung time na yon, dun sa kanilang bahay, si Arlene lang ang duguan. So, bakit merong nagkaroon ng stained ng blood yung shirt and brief ni petitioner? Nung time din na yun, walang kahit anong dugo or walang kahit anong scratches and bruises si petitioner. Next, we have the presence of petitioner's wife inside the house at the time does not likely negate the commission of the crime. Yes, nandun yung asawa niya. But, kakasabi nga kanina na pabagong anak. So, and his wife was a nursing mother who definitely had sleepless night. She could not be expected to be conscious of everything that happened outside her room. So, and more importantly, the intent to kill was duly established by the witnesses when they testified relative to the peeping incident. Kasi may dalawang incident or 2 occasions na may nakita nila na naninilit si Nover Bryant, the petitioner, kay Arlene, the victim. One was when she was taking a bath and while she was inside the room with Marian. So these pieces of evidence, the circumstantial evidence, the physical evidence, the testimonial evidence that was gathered and presented in court, helps the justice to be served. And lastly, we have the summary. So we have the sexual abuse and its types: the sexual assault, rape, child sexual abuse, and sexual harassment. The role of evidence, which the evidence plays a crucial role in establishing the facts and supporting the legal process. Third, the types of evidence. We have physical, testimonial, electronic, and character evidence. We also have the consent, in which in sexual abuse cases, the question of consent is pivotal and complex. And the sexual assault investigation kit, which includes the swabs, blood collection tubes, containers, documentation forms, seals and labels, comb and brush, photographic supplies, clothing bags, and packaging in envelopes. And lastly, the example case of Nover Bryant Salvador E. De Leon, the petitioner, versus People of the Philippines respondent. And that's all. Thank you.